For the first time in nearly 250 years of American history, a federal judge did something that no one expected. She declared that the courts had failed. This wasn't a rumor. This wasn't politics. This was a signed legal filing. On January 10th, a U.S. federal judge sent evidence of criminal misconduct directly to Congress. The name at the center of it all: Donald Trump. Judges give orders. Defendants follow them. That's how the system works. But this time, it didn't. Court orders were ignored. Warnings were dismissed. Contempt rulings were violated. Once, not twice, but again and again. So, the judge stopped escalating. Instead, she triggered a constitutional alarm. She warned that the defendant posed a clear and present danger to the justice system. And suddenly, America faced a question it never wanted to ask. What happens when a former president refuses to obey the law? And what happens when the courts can no longer stop him? This is not just a legal battle. This is a test of the American system itself. Let's begin. Before any of this makes sense, we need to rewind history. Picture a cold Saturday evening in October 1973. President Richard Nixon has just ordered the firing of the special prosecutor investigating Watergate. The Attorney General refuses and resigns. His deputy refuses and is fired, eventually. The order is carried out by the next official in line. History remembers this as the Saturday Night Massacre. But what people often forget is why the system survived that night. Not because the Constitution is magical. Not because institutions are invincible. It survived because individual people inside government chose integrity over obedience. Fast forward more than 5 decades. January 10th, 2026. Exactly 3:17 p.m. Eastern Time. Something happened inside the U.S. federal government that has no precedent in American history. A federal judge, holding a lifetime appointment, made a decision that may fundamentally alter the future of American politics. Judge Tanya Chutkan Privermulthum, D.C., took an action that has never once occurred in the 249-year lifespan of the U.S. Constitution. She formally transmitted evidence of criminal misconduct by a former president directly to Congress and urged lawmakers to begin impeachment proceedings without delay. Not Nixon, not Clinton, not during either Trump impeachment. Never before. This wasn't a leak. It wasn't a rumor. It wasn't an anonymous source. It was a 47-page legal filing, publicly submitted, signed by a federal judge. Her conclusion was blunt. The courts had exhausted their authority. The situation posed a serious threat to the justice system, and Congress had to act immediately. Judge Chutkan oversees one of the federal criminal cases involving Donald Trump for months. She had been facing a scenario no judge is trained to handle. A defendant who repeatedly ignored court orders, openly, publicly, and deliberately. Federal judges do have enforcement tools. They can issue warnings. They can impose fines. They can hold defendants in contempt. In extreme cases, they can even revoke bail. But what happens when none of those tools work? What happens when fines are meaningless because the defendant is wealthy? When detention becomes politically explosive? When warnings are treated like jokes? That was the position Judge Chutkan found herself in. Over a 3-month span, the court documented 14 separate violations of judicial orders. Gag orders were broken. Witnesses were contacted despite explicit prohibitions. Public attacks were launched against prosecutors, judges, and potential jurors. Each time, the court warned the defendant. Each time, contempt was issued. Each time, penalties increased. January 10th, the judge stopped escalating within the judiciary. Instead, she issued what's known as a criminal referral. In plain terms, she told Congress that the judiciary had reached its limit and that only the legislative branch still had tools powerful enough to address the threat. Her language was precise and severe. She wrote that the defendant's conduct represented a clear and present danger to the administration of justice. Those words carry extraordinary legal weight. They signal the highest level of institutional threat recognized in American law. Attached to the referral was a massive evidentiary record. Documented gag order violations. Transcripts from multiple contempt hearings. Phone records showing prohibited coordination. Social media posts targeting judicial officials. Statements from veteran federal judges describing unprecedented behavior. And most critically, recordings indicating intentional defiance of court orders. This wasn't about accidental mistakes. The evidence showed intent, deliberate planning, deliberate violations, deliberate escalation. Within hours of the referral reaching Congress, political gravity shifted. Lawmakers who had resisted impeachment for years began changing positions. By the end of the day, more than 230 House members had signed on to draft articles of impeachment, enough for passage. What made this extraordinary wasn't just the number. It was who joined. Moderate Republicans, members from swing districts, lawmakers who had previously defended Trump. Publicly, they cited one reason: their oath to the Constitution. Privately, the message was clear. Defending defiance of court orders had become impossible. Congress invoked a fast-track procedure, guaranteeing a full House vote within 72 hours. At the same time, federal prosecutors received the same evidence package, meaning criminal exposure was expanding alongside political consequences. Then came the response from Trump himself. A series of social media posts attacking judges, alleging conspiracies, and escalating rhetoric. One message, in particular, triggered alarm across Washington, interpreted by law enforcement as a call for confrontation. Security tightened immediately. National Guard units deployed. barriers erected around federal buildings. Law enforcement surged across the Capitol. This wasn't theater. It was contingency planning shaped by lived experience. Meanwhile, behind closed doors, discussions reportedly expanded beyond impeachment, including quiet consideration of constitutional mechanisms never expected to be relevant again. None of this guaranteed a specific outcome. But one thing became undeniable. This was no longer just a legal case or a political dispute. It was a stress test of the American constitutional system itself. And just like in 1973, the survival of that system didn't depend on words written on paper. It depended on whether people inside it chose restraint, accountability, and responsibility. The next days would decide which path the country takes.